of us have heard of the terms wills and trusts and have a basic understanding of how it works. Hi, I'm Christine Mattis from the Mattis Law Firm, and oftentimes you've heard me say how important it is to have these documents. But really understanding how these document works definitely has a lot of misconceptions that lead to misunderstandings and frustrations. I'm here to bust the three top estate planning myths. Number one, the reading of the will. Lots of movies, television shows, and books talk about the reading of the will, where the attorney gathers in a room and is surrounded with all the beneficiaries, and he speaks about what's in the will and who gets what. Well, today we don't have that. Historically, it was so important to have the reading of the will because of low literacy rates and the unreliability of the mail. Today, there are many ways in which correspondence can be delivered through mail, email, and fax. Plus, thankfully, literacy rates have soared. So communicating the will has become so much easier. A will becomes a public document, so anyone could get a copy of this will. But as a personal representative, it's so important for you to keep up communications with your beneficiaries so you can eliminate any problems about the will. Myth number two, if I die without a will, the state gets everything. When you die without a will, it's called dying intestate. And when you do die without a will, the intestate laws of the state that you reside dictate how assets will be distributed. Intestacy laws means that someone died without a will or the will was considered void. For example, in some states, a handwritten will, also known as a holographic will, is not recognized. Then that person would have to take a look at the intestacy laws of that state. If you die without a will and your beneficiaries are minors, they cannot collect. How are they going to receive your inherited property? Well, there has to be court intervention, like a guardianship. And at a certain age, the children then can receive their inheritance. But if you had a written will, you can avoid all of that. So it's so important to make sure you have something in writing. Myth number three, a will avoid probate. A will can do so many good things for us, but one of the things that it does not do is avoid probate. In fact, it's quite the opposite. A will has to be probated. So, what's probate? Probate is an administrative procedure where the will is authenticated and that the court oversees everything, making sure that the decedent's wishes are followed through as to who gets the assets, when, and how much. Having a will probated is not a bad thing, and in many states, it's very simple and very quick. But whether or not your family should go through probate is a whole different question. So, as you can see, there are many reasons why you should have a will in writing. But to avoid probate, that's a unique solution for our unique families. So, there you have it, the top three myths of estate planning. There are more. So, it's so important for you to click below, make an appointment with our team, and we'll be happy to go over more of the reasons why you should have an estate plan and bust more myths.